before us. So with that, I will now call the case of 124160. Mr. Smith.
May it please the court, justices, opposing counsel. I'm here on behalf of Grandmothers Inc. And Robert Zabel, and we have petitioned this court to review the opinion of the Court of Appeals as it relates to an appeal from the Shawnee County District Court. The primary issue I'd like to talk about tonight, we've raised two. The first one is that the appellate courts do not have jurisdiction to decide this issue, as the matter that was appealed was not a final judgment. The second issue that we've raised in our petition that's before the court, if the court considers it, is that the Court of Appeals erred in concluding that there was an issue of fact of whether there was a contract. What we are asking the court to do is to find on the first issue, which is that the Court of Appeals and the Supreme Court lacks jurisdiction over this appeal and therefore dismiss it. This would leave the case in the posture where there had been a motion for summary judgment ruling on a number of the counts filed against my client, and the remaining counts had been dismissed, and we would take the position that the case is concluded at this point. The time to appeal the motion for summary judgment or to conclude the case has lapsed. Let me fill in the gaps on that, justices. The case arose out of a construction. My client owns the building at 29th and Topeka, where the Kansas Department of Revenue has its driver's license operation. The KDOR is a tenant of my client. The KDOR decided that it needed some additional internal construction and sought a bid from Benchmark to perform some of the work. The dispute that was ultimately presented arose over payment and who Benchmark had a contract with. Parties presented summary judgment motions, and the trial court ultimately found and granted in our favor that of the 8 counts against us, counts 1, breach of contract, 4, 5, and 7, which dealt with the Kansas Fairness and Private Construction Act, the Public Construction Act, and the foreclosure of a lien, we were entitled to summary judgment on. In order to appeal this case, Benchmark filed a motion to dismiss its remaining counts, which would have been counts 2, 3, and 6, without prejudice. They then filed, also then further asked that the court make an order, which is before you, that all of the claims were dismissed without prejudice. My client had a small counterclaim. So the case then proceeded before the Court of Appeals with a manufactured jurisdiction. And I would suggest to your honors that the starting point for this is KSA 60-2102, which is the basis for the appeal. As the justices know, this court only has jurisdiction over specific cases. In the docketing statement, Benchmark cited KSA 60-2102 A4, that a final decision had been made in this case.
Counsel, do you agree that all the claims in this case were final as of October 2021?
I do not agree that there was a final decision on the merits. This court stated in the case of Kansas Medical Mutual Insurance Company v. Savate, SVATY, 291 Kansas 597, that the term final decision as defined in that statute has been construed to mean one which finally decides and disposes of the entire merits of the controversy and reserves no further questions or directions for the future or further action of the court. As of the time of the notice of appeal, that's not what had happened.
But as of October 2019, there were no claims that could be litigated at all after that date.
And the date you're conferring or referring to is the date the notice of appeal was?
No, the date the savings statute lapsed.
I wouldn't agree with that, Your Honor. These claims, that requires a factual determination. As Your Honors can appreciate, the statute of limitations is one that must be raised by a defense and also may be determined, requires a factual determination. So the assumption by the Court of Appeals and the assumption in that question, Justice Wilson, is that the underlying facts would establish that there could not be any other assertion of the claims that were dismissed, which were.
So you don't agree that all the claims that were raised can no longer be raised?
They were, what I would tell you is there's nothing in the record that establishes the factually that the underlying claims, which were for quantum merit or unjust enrichment, for conversion and unjust enrichment from additional work, they divided into two claims. One, what was the original bid, and then the extra work.
That's an interesting point, but that wasn't my question.
Okay.
That doesn't answer my question. Are there any claims that any party made in this case that can be litigated after October 19th, 2021?
Yes, these claims were dismissed without prejudice. There's nothing in our statutes or case law that prevents a party from filing a claim. The question is, once it's filed and the court addresses the factual and legal issues, does the court find that either the claim had been dismissed with prejudice, which these claims were not, or has there some reason as a matter of law or factually that the claim cannot be pursued when it's refiled? And that's the basis for our argument. And in fact, if you look at the case law, I think that's the case that what the courts have looked at on this. And I would refer you to it's a 10th Circuit case. It's Christina Consulting Group LLC versus Debt Pay Gateway. It's a Westlaw case, 2022 Westlaw 881575, which the court was looking at this in a similar context. And it said, generally, a party may not manufacture finality by obtaining a voluntary dismissal without prejudice of some claims so that others may be appealed. And what this court said in the prior case that I cited, which was the CAMCO, Kansas Mutual Insurance Company case, was that it's a decision on the merits. So in a voluntary dismissal without prejudice is not a decision on the merits. Meaning the case.
But the summary judgment order is still final, arguably, at least, once those other dismissed claims can't be brought back. I'm just wondering, is your position consistent with our precedent that has historically construed those jurisdiction statutes liberally to promote resolution of claims on the merits as opposed to procedure?
Yes, I think the court in the case of Smith v. Welch, 265 Kansas 868, that issue was not directly in front of the court. That's one of the courts your justices have looked at. If you look at the next case, and that was a 1998 case. If you look at the next case after that, which is Bain versus Archer, 217 Kansas 78, which is a 2001 case, it appears to me as I read the judgments or the rulings, the court begins to realize that it has allowed in that prior case a appeal to take place when there was a dismissal without prejudice. Because we have specific delineations. We have dismissals with prejudice, dismissals without prejudice, motion for summary judgment, et cetera. I don't think this is just a savings clause issue, because all that the savings clause does is allow, if you refile it within 6 months, your deadline for filing was the date you filed. That doesn't mean that there's not that the statute of limitations is run. Not at all. What it means is simply if you are trying to save a statute of limitations, there's been no evaluation by the trial court or the Court of Appeals of when would the statute of limitations begin to run on these cases or claims that were dismissed without prejudice. You don't have that before you. And that's why we've suggested that you don't have jurisdiction, because the plaintiff Benchmark could have tried the remaining cases. After the trial court dismissed a number of the counts, there were still several counts left that the plaintiff could have tried.
But weren't they all tort claims?
Pardon me?
Weren't they all tort claims with
Yes.
2-year statutes of limitations?
From the date harm occurs, and the court, there's no finding in the record of when that occurred as it relates to conversion claims or I always forget the last one, Your Honor, the conversion and the unjust enrichment claims.
But aren't we to view all of the facts, and we know they were tort claims that were dismissed without prejudice. aren't we to view all of the facts in a light most favorable to Benchmark?
Justice Wilson, the way I look at this is you have to interpret what the statute says. The statute that confers appellate jurisdiction upon this court. And what the statute doesn't say is that an appeal can take place so long as the time limit runs while the case is pending on appeal, or so long as meaning that the claims that were dismissed without prejudice. It doesn't say that you can confer jurisdiction as you move through the case. It says that and clearly at the time of the dismissal, when the appeal was taken, it was within the 6 months. So if we're going to look at the savings clause that says if you file it within 6 months, it relates back. While 6 months into the appeal on this is when finally it would have become ripe for jurisdiction. That's not what the statute says.
Well,
The sorry.
statute says it has to be final. So whose burden is it to show the court that all claims are final in that they cannot be raised, they cannot be litigated? They're either tried on the merits or they're too late to file.
This court has an opinion that says it's the court's job to always check to see if it has jurisdiction. I would also suggest that KSA 60-254 allows a party to obtain a order of finality, that the judgment is final as to all issues in an appeal. The plaintiff could have dismissed these causes of action with prejudice. And Your Honor, I see that I have ran out of, Justice, I've ran out of time.
You can continue to answer. Thank
I've
you.
finished my argument.
Yes, you please
So-
continue.
So the plaintiff could have dismissed its causes of action without or with prejudice. Plaintiff specifically moved to dismiss them without prejudice, meaning the plaintiff was giving itself an extra opportunity at some point to possibly assert these claims again.
May I ask?
Yes, go ahead.
But our court has allowed notices of appeal to be filed before a judgment became final since at least 1979. So why should this case be different?
Just based on the case law and the statute. It says it has to be a final decision, and it says that a final decision is one that doesn't leave any opportunity for there to be a relitigation of the lower court of cases or claims that were dismissed without prejudice. The problem with this is then when do you have jurisdiction? Is it what if they dismiss a contracts cause of action that has a 5-year statute of limitations on, and they're not worried about the savings clause, Justice Wilson, which means once the case is decided and it goes back down to the trial court at, let's say, 2-year mark, that plaintiff now gets to fractionalize this litigation and re-add that contract. We could brainstorm and come up with multiple types of causes of action that if the ruling of this court is that jurisdiction can be conferred based on a dismissal without prejudice, then what you are most likely going to see at some point is these claims being added back in after pieces of the case are decided, and that you have a statute for that. It's called an interlocutory appeal. And the plaintiff did not ask for an interlocutory appeal. See, there are multiple avenues where the plaintiff could have addressed this very easily and not put the court in this system, in this situation. Thank you, Justices.
Thank you. Ms. Lewis?
May it please the court, Diane Lewis for Benchmark Property Remodeling. We're here today to ask this court to affirm the judgment of the Court of Appeals, which reversed and remanded the granting of the judgment on the pleadings and the granting of the summary judgment for further determinations by the district court. And I think that Mr. Smith actually said it best at the beginning of his argument, where he said that he hopes this case is dismissed. And if the appeal is dismissed, there are no more claims and the case is over. And to me, that says that we've got a final judgment here, that we have a situation where there is no chance of piecemeal litigation. As several of you have pointed out, there are no claims remaining that could be refiled, that could put us in a sticky situation where there's multiple claims that aren't resolved on this appeal. Everything is coming, will be determined by the outcome of this appeal.
I think what he's saying, and help me figure this out, is that even though we have the savings clause,
Mhm.
you know, which, and his position is that the savings clause is there to preserve the date of the original filing. That I wrote down what he said, there is nothing to prevent them from refiling the quantum merit, the conversion, and the unjust enrichment claims. And maybe after they file those, they would be dismissed on, you know, on a statute of limitations, but that they could still file those claims, but there would have to be factual findings and that the law would have to be applied. Well, the law would have to be applied to the facts, and factual findings would have to be made before those could be dismissed. And if that were true, how would you respond to his argument?
Well, I would disagree with that. I think we can all look at tort claims and know what the statute of limitations are and know the effect of dismissing those claims in the savings statute. But I would also point out that if we're going to take the argument to that conclusion, that we have to take it to the logical conclusion in every case. Just because a case is dismissed with prejudice, technically I could still refile it and force a court or the opposing party to file a brief to dismiss my claim because it's barred by res judicata, or it's barred by, you know, the statute of limitations, or it's barred by a prior order in another case, or it should have been filed with another as part of a different litigation. So I think that argument is always out there. I mean, anybody can file anything, and that if we're gonna you know, pretend we don't know what the statute of limitations effect would be and say, well, this could still be a final judgment, then I think we have to do that with everything. And I think where this case really is similar is with Supreme Court Rule 2.03, where if you do have this essentially is a premature notice of appeal. And it's always a tough situation where you've got a summary. My client was faced with a situation where he had a summary judgment and a motion for judgment on the pleadings. We believed that the district court got it wrong. The Court of Appeals agreed with us that the district court got it wrong, and my client had to make a choice. Do I want to pursue my main claims, or do I want to pursue some other claims I have that are a little bit smaller but are important to me just the same? And I think that puts litigants in a difficult situation. And so we dismissed without prejudice and with no intention of refiling, but that's a difficult call to make in the moment. And
For 6 months, you could have.
I could have, we could have, and I guess maybe this goes to my practice as an attorney, but it never would have dawned on me to ever pursue a claim and an appeal on the same issues. But I can certainly see how it apparently has happened in the past. And
What's your best argument? This case was filed before any briefs were even filed in the appellate courts.
what's my best what?
What's your best argument that this case, all the claims in this case were filed before any briefs were even filed in an appellate court?
I'm not sure I understand the question.
You had the dismissal without prejudice,
Mhm.
and the savings statute period of 6 months ran.
Mhm.
Was the case final on that day?
I believe so, yes.
Why? What is your best argument?
My best argument is that the statute of limitations had expired, the savings statute has expired. There is no way that a valid claim could be brought on those claims against grandmothers or Mr. Zibel in any fashion. The claims were done. It promotes the court's goal of avoiding piecemeal litigation. It promotes the court's goal of a liberal interpretation and liberal construction of civil procedure statutes to ensure that cases are tried and decided on the merits, to eliminate traps for attorneys and eliminate traps for pro se litigants. And it promotes the court's goals of resolving these cases in a logical way that promotes judicial efficiency. And I think that this, the pursuing the appeal in this way, concluding that that was a final judgment, that if anything, the notice of appeal was a bit premature, but ripened before the Court of Appeals read any brief, before the Court of Appeals made any determination on the case, that this case can be reversed and remanded, that the claims can be decided on the merits by the district court, and that we can get a full and final determination of all claims and have no pieces outstanding and no loose ends to tie up.
What?
As I understood at least a portion of Mr. Smith's argument, we don't have, it was that we don't have before us the things that we need to make the conclusions you were asking us to make. In other words, that those are usually things, including questions of fact, defenses that need to be asserted, that have procedurally, those steps have not occurred here. So how do we cure that to be able to get to a ripened a judgment or for the premature appeal to have ripened so we would have jurisdiction?
I guess I would say we do have that information, and that we've got the dismissal without prejudice that identifies all of the claims that were dismissed without prejudice. I think that we can take that, we can look at the statute of limitations, and we can look at the date of the dismissal, and from that conclude that there are no further claims that could be brought in as part of piecemeal litigation, and that these are in fact the only claims that will ever be decided on the merits by a court.
Is this really how we want the procedure to work? And that it's the court's burden to say, okay, when this, we'll talk about the Court of Appeals for a minute. Okay, Court of Appeals, this case has come to you. They do a jurisdiction check. You may not know that, but okay, there's no jurisdiction right now because this was dismissed without prejudice, but let's hang on to the case for a while and let's wait to see whether or not they, refile the case. And then before we read the briefs, then maybe they'll refile it. And then, okay, now they didn't refile it. So we're just going to assume that we now have jurisdiction because now it is final. So let's construe this as a premature appeal because, we have, the Court of Appeals has 1,600 cases filed every year. And then when we pull it up, is this our duty, our burden as the court to do this? Or is it your burden to say, okay, this is what we want. We want you, the court, the appellate courts to have jurisdiction. So we're going to dismiss these 3 claims with prejudice so that it's clear to everyone. And, what should we do with this? It's kind of like you want us to make a law out of bad facts.
And I understand that. I don't think this would be making a law out of bad facts. I think this is an unusual situation that I really didn't see replicated in any research that I could find that was really on par with exactly what happened here. So I think this would be just looking at the existing case law, the existing rules, the existing procedures, and the existing intent and existing policies of the court and the judicial system to hear cases on the merits, decide cases on the merits, and to eliminate potential traps for attorneys and pro se litigants, and look at what we've done in other cases and view this as analogous to those situations, and analogous to a situation where there's a slightly early appeal, or analogous to a situation where claims were dismissed, but they weren't refiled. So they weren't something that the court took up. And I think in the Smith case, the court declined to hear cases that were dismissed without prejudice. The opposing party wanted to bring up an issue on a case on one of the claims had been dismissed without prejudice, and the court said, no, we're not going to hear that. But what they didn't say is, well, hey, these claims were dismissed without prejudice. how do we have jurisdiction on this appeal? And so I think that there's, I think that it's not something that comes up often, and that we can resolve it consistent with the court's prior rulings and opinions.
Do you know whether the savings statute, which, after a party secures a dismissal without prejudice, generally has 6 months to refile those claims, is that statute subject to equitable tolling? Can a district court judge find that under certain circumstances, the opposing party engaged in deceptive or fraudulent conduct that prevented the party from refiling, that then should equitably extend that 6-month period?
I do not know the answer to that off the top of my head, to be fair. I know that underlying statute of limitations can be equitably told, but I don't know about.
Well, if it could be, does that change the question about finality here? That maybe it's not so cut and dry whether or not a 6-month period should, the lapse of that 6-month period should sort of mature into appellate jurisdiction.
I'm not sure I know enough about the case law to.
I have a quick follow-up on
think
that.
sure.
Are you relying exclusively on the idea that your dismissed claims are barred by the statute of limitations to support your argument for jurisdiction? In other words, what if obviously there was no statute of limitations problem?
If there wasn't a statute of limitations problem, or if there wasn't a statute of limitations problem, I suppose I could, I guess I hadn't thought about it in
Well,
that terms, but
let's
essentially, yeah,
consider that
yeah.
the rule, whatever rule gets adopted in this case might
Yeah.
have to apply in a future case in which
Yeah.
we have, let's just say, a very long statute of limitations, 10 years, whatever,
Mhm,
so that no longer becomes a factor
mhm.
in future cases. I mean,
Yeah.
do you think there's appellate court jurisdiction in a case where summary judgment's granted on some claims, other claims are dismissed? No one is concerned about them being barred by the statute of limitations.
Mhm. Well, I think in that case, there would be an argument that you wouldn't have a final judgment because you do have a claim that
So
could be
my
refiled.
follow-up to
Yeah.
that is why? In other words, how is that any different from the circumstance in which you had filed the claims which were ruled on in summary judgment and simply hadn't filed the other claims?
Mhm.
Is there any difference between this case and that one that I just described?
In a case where I just hadn't filed these claims,
Yeah, they just hadn't been
they
filed.
hadn't been filed. And I don't think there is. I think there's always that risk out there that you could have claimed that any party that's got an appeal could have a claim that wasn't brought in the underlying case that they could refile. And
It seems odd, at least, to think that appellate court jurisdiction might hinge on whether or not a now dismissed claim had either been filed or never been filed. And why should that matter, I guess, is the question.
yeah, I guess I would agree with that. I think that, that if there's a claim that hasn't been filed, we could never know.
So in light of that, it
With
strikes me that your answer to my earlier question must in fact be
Yeah.
you're not relying on the statute of limitations.
I guess I'm not relying on the statute of limitations in that regard, and that there's always conceivably a claim that hasn't been filed. And I mean, any party could have one. In this particular situation, I am relying on the statute of limitations in the sense that if we would have dismissed the claims with prejudice, those specific claims could not be refiled. And in this case, in this situation, even though they were dismissed without prejudice based on the statute of limitations and the equitable toll and the savings statute, we also cannot refile. So they are effectively equivalent, just because I've got either with a dismissal with prejudice or a dismissal without prejudice and an expiration of the statute of limitations and an expiration of the savings statute, both result in situations where my client has claims that it can never, ever refile. Now, whether there's other claims out there that aren't part of this lawsuit that haven't had their statute of limitations elapse, it would be speculation. I see I'm out of time.
Benchmark had filed one of these hanging claims after you filed those.
Mhm.
What would happen to the deal? Wait.
Well, I mean, we would have had to have done that before we filed our brief. So I think that would, I don't know if you can divest jurisdiction from the Court of Appeals, but I think that would make a judgment on final, I guess, as in the cases where they
Go back
refiled.
and forth, file claim. You don't file the appellate court. Done it.
As refiled as an answer. Yeah.
Starting to get warming up a little more to the other side of the argument about the fact that the court ought to be able to look at its own records and know everything
Mhm.
is lined up and proper, as opposed to not knowing
Yeah.
or having to rely on the lawyers to tell us that the claim has been refiled.
Yeah.
And so now we should do something about jurisdiction. We've had cases where the lawyers wanted the answer to the question,
Mhm.
didn't really concern themselves that there might not be a final judgment.
Yeah. And I think where you've got a goal of circumventing the process, I don't know that you can ever create rules to prevent that, because the whole goal there is to avoid what you're supposed to be doing. So you can say, hey, do this, and you're always going to have people that try and go around it. But I think that ties back to the argument of, well, you could always have a claim that wasn't filed in the underlying lawsuit. You could always have a claim that is being brought separately. You could always have somebody that refiles a claim that's been dismissed with prejudice. And I mean, those are all, there's an infinite number of possibilities that that could make a different outcome or could cause problems with jurisdiction. But I think in this particular case, yep. Yeah, in this,
The one who did bring.
sure.
And so if we're thinking about a research attorney
Mhm.
assigned to the job doing a jurisdiction check and what we file, they're looking to filing a whole here are these 4 claims, they've been dismissed without prejudice. Are we really supposed to decide that, oh, well, the statute of limitations is run, so we ought to go ahead and decide this? But our file, that would require something extra. And one side or the other, may not even agree with that.
I think that's always a possibility with any determination or with any consideration, that there can be outlier situations. But
Are there other questions?
then I would ask that the court affirm the Court of Appeals judgment, reverse and remand this case to Shawnee Circuit Court, District Court.
Thank you. Mr. Smith, you reserve 5 minutes.
I'd like to pick up with Justice Biles' question about the filing of a cause of action while a case is pending. He may have been alluding to the case of Arnold v. Hewitt, which 32 Canap Second 500. It's a 2004 case where that did happen. And the court concluded in that case that getting back to this issue of you can't manufacture jurisdiction kind of after the fact, that to allow the plaintiffs to proceed in this fashion would render meaningless the statutory provisions invoking the jurisdiction of this court. Since a final decision must dispose of the entire merits of the case, it is impossible to conclude that a final decision has been rendered in a district court to allow appeal. there is a reason for that. And I would also suggest that the saving statute is not, you're not precluded from filing an action more than 6 months after you've dismissed it. What it does is it saves your statute of limitations if you have a case on file on time. And in fact, the saving statute, 6518, says that if an action is commenced within due time, meaning you put your flag in on the filing date, and the plaintiff has failed in such action otherwise than on the merits, and the time limit for the same has expired, the plaintiff, or if the plaintiff has died and the cause of action survives, his representative may commence a new action within the 6-month window after such failure. It's to save the statute of limitations. It's not to confer jurisdiction. If I dismiss a case and the statute of limitations still has 2 years left on it, I can refile it more than 6 months after I've dismissed it, as long as I file it within the statute of limitations. This protects my client if the statute of limitations had ran after I filed the case and commenced the case, which, as your justices know, is that we commence it by filing and service. Then I have the case properly commenced. And so that is not the statute's not intended to confer jurisdiction.
I wanted to, before your time runs out, give you an opportunity to answer the question I asked your opposing counsel, which is, how is this case different from a case in which the dismissed claims were never filed in the first place?
So the way the statute's written, it only speaks to a final adjudication of claims before the court. We would have no way to know what claims were unfiled.
But doesn't that cut against your argument? Because dismissed claims are effectively identical to unfiled claims, are they not?
No, a claim dismissed with prejudice is a filed claim that has been resolved and cannot be refiled.
Fair enough. But with respect to claims dismissed without prejudice, I mean, how are they different from a claim that was not filed in the first degree?
Because the purpose of the appellate jurisdiction statutes are to allow the Court of Appeals to decide all of the claims presented in that case, not claims that haven't been asserted, but all of the claims presented.
And your argument is that a claim which was filed and later dismissed without prejudice effectively, well, it becomes presented essentially.
Yes, and I was going to refer your honors to an opinion authored by Justice Stanbridge that I believe might be relevant to this analysis. And it's the case of Harrington versus City of Wichita. And it is 314 Kansas 447. It's a 2021 case. And in that case, this was where a case had been filed in federal court and included state claims, and the state claims had been dismissed without prejudice. So the question was, could the person then file those state claims in state court? And in conclusion, the court states, whereas here a federal court declines to exercise supplemental jurisdiction over state law claims and dismisses those claims without prejudice, we hold there has been no final judgment on those state law claims, and the Kansas common law doctrine of res judicata does not apply. So this court has found that a claim that's dismissed without prejudice, that it has not been adjudicated on the merit, and in fact can be refiled in state court.
So just a real quick follow-up.
Yes.
If the rule that you're advocating for suggests no appellate jurisdiction whenever there have been claims dismissed without prejudice, what would happen if a plaintiff filed a lawsuit and very quickly decided to dismiss certain of the claims that were made, perhaps even prior to the filing of an answer? So you get a lawsuit filed and several of those claims are quickly dismissed without prejudice. Then years go by, parties litigate, go through discovery. We sort of follow the track we're on, summary judgment ruling, still no appellate jurisdiction?
254 allows a litigant then to seek an order from the court finding that all of the matters have been adjudicated in the case. That didn't happen here. That's the purpose of that.
So you think that would require an interlocutory appeal? Is that what
Pardon me?
are you saying that that would require an order for an interlocutory appeal?
So an interlocutory appeal is not what was taken in this case.
Right.
This was.
I'm just trying to figure out how you would articulate appellate jurisdiction in my scenario.
So in your scenario, what I believe a plaintiff should do at that point, if so the case proceeds forward, if I understand under your example, the claims that are dismissed aren't ever brought up. Let's assume the case is tried. Then it's been decided on the merits.
So I don't understand how the rule you're asking us to adopt would be articulated. Because it sounded to me like from your earlier argument, if there had been a dismissal without prejudice at any stage of litigation, even very early on, that would deprive any appellate court of subsequent jurisdiction.
I think you articulate the rule and follow the statute, which
Well, I'm
says that it
asking-
has to be a final decision on the merits is what this court has said. And it's not.
And you're advocating that anytime there's been a dismissal of any claim without prejudice, the resulting adjudication of the remaining claims are never final. That's what I understand you to be saying.
And that's why I'll finish it, yes. And that's why we have a statute that allows for a litigant to ask for a ruling from the court that it is a final judgment as to all of the claims. There's protections. This plaintiff had multiple options to choose. What this plaintiff chose to do was dismiss without prejudice and appeal.
What if the district court declines to certify it as a final judgment?
Yes, you have case law now where they have declined to find that the court did it properly. They send it back down. Your honors have sent these cases back down for the court to make the proper findings. And you know how that can be fixed. The plaintiff can agree to dismiss those cases with prejudice. There's multiple, the rules already have plenty of options for a litigant to choose from if they want to try to finalize a judgment. They can either ask for an interlocutory appeal, they can dismiss with prejudice, they can ask for a 6254 final ruling, they can try the claims and get a judgment.
You know what I don't understand is the disconnect for me is that you keep talking about a final judgment on the merits. But let's say that it goes back down and the judge, you ask for a final judgment and the district court dismisses with prejudice. That's not on the merits. They're not deciding the merits of the claim.
A dismissal with prejudice has to be a finding by the court. The court's
not, the court is saying, this is dismissed, but there are dismissals that are not, for example, like a statute of limitations. You dismiss and it's a final judgment, but that's a procedural issue. That is not on the merits. So I could have a great claim, okay? And on the merits, I'm right. I mean, this was a giant truck that hit, this person and the truck driver fell asleep and this is a meritorious claim, but I waited, 4 years to file the claim instead of 2. And so it's kicked and it's dismissed and you can't refile it because you blew the statute of limitations. That's not a final judgment on the merits. It's a final judgment because you blew the statute. So you keep talking about on the merits, but I'm not getting it.
I would suggest to Justice that a finding that the statute of limitations has expired is a finding. The legislature has
Right,
established.
I agree, it's a finding.
It's a finding of fact. It's a finding on the merits. It's a fact. The legislature,
merits of the underlying claim.
certainly the legislature has determined that there are limits on when you can file a claim. That's why under 6513, which is the statute of limitations for court cases, that's why there are 446 cases that cite to that statute, because when the statute of limitations accrues and when it runs, it has been hotly litigated for decades. And it is a factual determination and it can be waived if it's not asserted. That's in the case law. It can be waived if it's not asserted, and it is a factual determination. And so, yes, it is on the merits because what the legislature has, I would suggest to your Justice that it is, because what the legislature has determined, which is that a claim no longer has any merit after it's so many years have passed since the harm or injury occurred. Just like the statute that confers appellate jurisdiction says it has to be a final decision, on the merits. And so I would suggest that the statute of limitations decision is in fact on the merits. The merit is you have to have a valid claim, right? And is it still a valid claim? Then you have to prove that there was a duty and a breach of the duty.
Right, I understand your position. Let me ask one more question. So, what you said kind of triggered something for me, which is, do you agree or disagree? Do you believe that the statute of limitations, if you blow the statute of limitations, is that subject matter jurisdiction? Or there are exceptions, correct? Well, there are exceptions to it, right?
So then is it a 6212B, like lacks subject matter jurisdiction, failure to state a claim, those types of things?
Basically, I'm asking, when you're talking about, so for example, that could, if the statute of limitations here was a year, okay, and the saving statute goes by, and then now there's you blew the statute of limitations. You can't file this action anymore. But there are exceptions, right?
Sure.
Like
Fraud. If it was
fraud, right? I mean, there are certain exceptions.
disability, if the person was
Right.
a minor, yes.
So just because that 6-month window passed doesn't mean that it couldn't be refiled, right?
That's correct.
So that's your position.
And in fact, if the defendant didn't raise the statute of limitations as a defense to place it in front of the court to be ruled upon, that's the court's job, then that case would proceed possibly to a final judgment on a case that the statute of limitations has run.
I think I understand your position.
Thank you for your time, justices.
Thank you. Thank you to both counsel for your arguments this evening. The court will take this appeal under advisement.